This case concerns one of the emotes, a Halloween-themed emote called Pump It Up that Epic Games made available for a single day shortly before Halloween in the fall of 2019 as part of its annual Fortnite Mares event. It's just green screen dancing. He was prepared to engage legal counsel to insist in seeking injunctive relief pending a resolution of the dispute. Okay, well now that's a real legal threat.
So going down the rabbit hole, we've discovered a lot here.
Yeah, and we're not done. What are they talking about with this license? Holy mackerel!
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
You might remember that a year ago we had a discussion about whether you could copyright Fortnite dances. So then what the heck is Epic Games doing suing a Fortnite dancer? This is the case of Epic Games versus Sick Picnic Media and Matthew Geiler. Plaintiff Epic Games, by and through its attorneys Kirkland and Ellis, hereby alleges against Picnic Media and Matthew Geiler as follows. Epic Games has been forced to bring this action, seeking a declaration that, contrary to infringement claims asserted by defendants, the Pump It Up emote in Epic Games' fantastical multiplayer game Fortnite does not infringe their copyright or trademark rights. So wait a second. It looked like for a moment there that Epic Games was suing a dancer, and they are, but it seems like the dancer was going to sue them first, contrary to infringement claims asserted. So infringement claims were asserted by defendants. So they explain what Fortnite is, and then we go on. This case concerns one of the emotes, a Halloween-themed emote called Pump It Up that Epic Games made available for a single day shortly before Halloween in the fall of 2019 as part of its annual Fortnite Mares event. In the Pump It Up emote, the avatar performs a brief dance to a Halloween-themed song developed by Epic Games, while the head of whatever avatar the player has selected is transformed into a jack-o'-lantern face designed by Epic Games. The jack-o'-lantern face has moving green flames pouring from the eyes, nose, and mouth, a broad grinning mouth, a long prominent stem that curves, and dark striations delineating the segments of the pumpkin, giving it a yellow and orange design. The Pump It Up emote can be performed by any avatar in the game, including fantastically dressed male avatars, female avatars, and avatars of other species. Let's go take a look at what the Pump It Up emote actually looks like. So there's like a sort of a move. So there's like a little back and forth move, a 180 with like a single kick, and then there's like a little hand thing and a head twist. So that's the entire dance. Now, if you remember from last year, the standard is a series of choreographed moves tied together in such a way that creates a longer performance. And the performance has to be the exact same moves over and over again, and it has to reach a level that it can be described in prose, and it cannot just be a simple sequence of dance moves. It has to be more like choreography to an entire musical or a ballet or something like that. Simple dance moves take advantage of the human body, and the human body is only connected in so many ways. In other words, I can't make up a dance move where my arm disconnects from its socket and flies around and then reconnects or something. I can only make a dance move that my arm moves from its connection point. So there's a limited number of moves. So to allow someone to copyright simple dance moves would allow them a monopoly over basic humanity. And then we would have tremendous lawsuits and things and history. How would you figure out, like, okay, well, this guy in 2019 made a dance move. Well, I mean, anybody in the history of humankind could have made that dance move. So how do we really know that that dance move is not already in the public domain? And are we really going to spend millions of dollars hiring historians and investigators to figure all of this out over simple dance moves? No. Defendants have alleged that the Pump It Up emote infringes their copyright to a character, which they refer to as the Dancing Pumpkin Man, that appeared in a video which defendant Geiler is dressed in a plain black unitard he did not make, wearing as a mask a jack-o'-lantern decoration he did not create, dancing to a song he did not write in front of a static generic graveyard image, the video. A true and correct copy of the video is attached as Exhibit 1. Now, I'm not sure how they attached the video, but let me see if I can find it here. What did we say the name of it was? Sick Media Productions or something? Sick Picnic Media. Let's see if we can find the Sick Picnic Media Dancing Pumpkin Man. Let's do a search for that and see what comes up. And it's from September 16th, 2019. It's got 249 views. I don't know if that's exactly the same one, but it's got the same name, and it's around the same time. I don't know, let's see. This one is by Tubi Vice Media. Dancing Pumpkin Man, courtesy of Sick Picnic Media. So there you go. So that is what they're talking about. So let me take a little bit longer look at this. It's just green screen dancing. So apparently then, this person threatened Epic Games with some kind of copyright infringement lawsuit. Defendants have alleged that the Pump It Up emote infringes their copyright to a character, which they refer to as the Dancing Pumpkin Man. There is no infringement here, however, as defendants do not own a protectable character, and the jack-o'-lantern-headed figures are in any case not substantially similar as a matter of law. Defendant's alleged character is not protectable, as it is not sufficiently delineated as a matter of law. Rather, it is simply the idea of an ordinary jack-o'-lantern head on a nondescript, plain black unitard body. This does not rise to the level of specificity needed to create a copyrightable character. Moreover, defendants did not create the attributes of that alleged character, and thus they cannot own a copyright to them. Defendants have admitted that he did not create the face of the jack-o'-lantern, rather he took a pre-existing third-party Halloween jack-o'-lantern decoration from his company's holiday display lobby and fashioned it into a mask. So, in other words, although he transformed the physical embodiment of the mask from like a jack-o'-lantern to a piece of plastic that he could strap to his face, he didn't create the face of the jack-o'-lantern, so he can't even say that the face is an original thing from him. In any case, these pre-existing materials are not substantially similar to Fortnite's Pump It Up emote. In contrast to the emote, defendants' alleged character's jack-o'-lantern face has a narrower mouth, smaller aperture to the eyes and nose, there are no moving green flames shining through the holes, its jack-o'-lantern head is smaller than Fortnite's Pump It Up emote, and is a uniform orange color as opposed to striated yellow and orange tone design. The stem on defendant's jack-o'-lantern is smaller than the stem on the Pump It Up emote. The bodies and costumes of the figures, I appreciate that they're doing all of this for everyone's clarity, but I don't think they have to do any of this. This does not rise to the level of copyright infringement. You cannot copyright a man with a pumpkin on his head. You can make a specific version of man with a pumpkin on his head, and yours will be copyrighted. For example, Epic Games can't go and take Dancing Pumpkin Man's video and put it in Fortnite. That's copyright infringement. What would Epic Games have to have done? They would probably have to have copied his moves in the video verbatim from beginning to end. And even then, that might not be exactly a level of copyright infringement that would be able to be adjudicated by a court. Because again, simple dance moves aren't something that's able to be adjudicated. But let's take it one step further. Let's pretend that he sues them, and then in the lawsuit they admit, we saw your Dancing Pumpkin Man video and it inspired us to create our own. And instead of creating our own, we just took a copy of you. We cut you out of your own green screen. Like we just rotoscoped every frame of it manually. It would cost millions of dollars. And we rotoscoped you and we put your physical video into our Fortnite as the Dancing Pumpkin Man emote, and we didn't contact you to get a license or pay you for it, even though we're one of the richest game companies in the world. That's what they would have to do for it to be copyright infringement. Could someone commit copyright infringement over simple dance moves? No. If I make a dance move right now, let's say I do this with my hands and then go right, and then spin my hands again forward and then go left, and then spin my hands again and go right, and then spin my hands again and go left. Guess what? You can go do the exact same thing and there's no copyright protection. Even if I went and registered a copyright, even if I asserted copyright infringement, even if I used the Circle C and said all rights reserved, that doesn't change a damn thing. Simple dance moves are not protected by copyright. And then they're going to make a trademark argument as well. This is not trademark. Like, it'd be one thing if he was selling a product, but if you make a video of yourself dancing and that's on YouTube and you're trying to get views, it's not trademark infringement for someone else to make a video of themselves dancing. It would be trademark infringement if we confuse the sources of the video. So if Dancing Pumpkin Man's dance and Fortnite's dance are so trademark similar, then you would watch one and think of the other. You would go, oh, I thought I was in Fortnite, but hey, look, Fortnite used Dancing Pumpkin Man's dance. That's super not a trademark claim. Try to take it once. How we have to keep going further with hyperbole in order to find the line, right? So if Dancing Pumpkin Man, let's say that Dancing Pumpkin Man was the advertisement for a local used car dealership. The music played and Dancing Pumpkin Man did this exact video, and during the video it said, buy used cars at Joe's used car lot. Now at least it's being used as a trademark. Now at least it's being used to steer people towards Joe's used car lot or sales or whatever. Now, if Fortnite put that video up and said, watch this Dancing Pumpkin Man video, and here's going to be text on the bottom that says, play Fortnite. Well, then the used car dealership probably has some kind of trademark claim against Fortnite. Do we see how different that is than Dancing Pumpkin Man putting up a video of himself dancing on YouTube and then claiming that that's the trademark for his company? Not quite the same. Or a trademark for a product. Not quite the same. The product is the Dancing Pumpkin Man video, so it's not quite trademark. I'll let them explain it. Defendants' trademark claims similarly fail because symbols may serve as trademarks only where used in commerce to identify the source or origin of a product or service. They must also be distinctive for such a product or service. Yeah, I skipped that. The Dancing Pumpkin Man is none of these. So what is distinctiveness? It's the level of trademark, distinctiveness or protection. A mark like Joe's used car sales will have almost no distinctiveness, whereas using a made-up word like Xerox to sell copiers is the most protectable trademark. You completely made up the word. It is arbitrary. It is fanciful. It is Apple computer when apples have nothing to do with computers, not apples to sell apples. You can't say Joe's Apple sales to sell apples. Doesn't get the same level of protection as Apple computers or Xerox. Moreover, the First Amendment protects expressive works like Fortnite's Pump It Up emote, as Epic Games' use is artistically relevant because it allows Fortnite players to express themselves during gameplay. Okay, true. I appreciate that. And I've often argued that streaming a video game is fair use because the video game does not play itself. You must creatively interact with it, expressing yourself through it. So I feel that that's transformative. It adds something, making it a new work that was not the same as a static work that doesn't do anything unless you press buttons. But I don't think anyone's actually challenged that yet. Maybe they know better. Moreover, as discussed below, defendants' claims are also fundamentally flawed, as no protectable elements of the video or character have been used in Fortnite without defendants' authorization. This is because defendants already granted Epic Games a license to the character, the video, and the content? What? he granted them a license? Now I gotta scroll down and find out. I already explained why I think it's not copyright and why I think it's not trademark. So why don't we not go through the next 30 pages of complaint and just let's try and skip straight to what are they talking about with this license? All right, so they go into some background about Fortnite and avatar customizations and emotes. The jack-o'-lantern mask in the video is a pre-existing Halloween decoration that Guyler found among holiday decorations in the lobby of his news station. So he works for a news organization. A true and correct copy of the transcript from a radio interview in which he discusses the origin is Exhibit 10. So we could try to take a look at that. And Epic talks about there being numerous previous examples of jack-o'-lantern characters. People associate jack-o'-lanterns with Halloween. The jack-o'-lantern head predates defendants. The 1904 children's novel The Marvelous Land of Oz featured the character Jack Pumpkinhead, which also subsequently appeared in the 1994 Oz comic book series. There's an image. Disney released an animation, The Legend of Sleepy Hollow, in 1949. Yeah, that was a scary movie from my childhood. And it depicts the iconic headless horseman holding a jack-o'-lantern to represent his head. An image of the headless horseman character is shown below. And so, again, they say that they're not depicting Dancing Man, they made their own. I pretty much agree with that. Let's see if we can find how he allegedly gave them a license, though. August 23rd, 2019, Epic Games and Sick Panic Media entered into a license. The license grants Epic Games the right to use the audiovisual work as shown in the video in Fortnite. The license provides that the agreement constitutes the entire understanding between the parties hereto regarding the subject matter hereof and cannot be altered or waived except by writing. In October 2019, defendants admitted that the license covered the rights that they now sought to enforce against Epic Games. Specifically, before the release of the Pump It Up emote, Guyler commented on a Facebook comment displaying Fortnite's Hollowhead skin, which was originally released on October 13th, 2018, and made available during the 2019 Fortnitemares event. As shown below, Guyler commented, "Luckily they did a licensing deal with me ahead of time." And so it says, imagine what I could do as a Fortnite skin. Wow, I read that sentence too fast. Matt Guyler, where have you been? They already have a bit of your style. Luckily, they did a licensing deal with me ahead of time. Okay, I mean, I would like to see the license, but I believe them now that they've shown me that. As the post did not reflect defendant's stance, but rather just a jack-o'-lantern-headed character, it is a clear admission that defendants recognized that the license conveyed the rights that they now seek to enforce against Epic Games. And then, why are we here in court? So a little-known requirement of federal court is that you have to have what's called a case or controversy. And this involves mootness and ripeness, whether or not the parties actually have a real and concrete imminent dispute between them. I'm mixing some words, other attorneys, I apologize. But whether or not the parties really have a dispute that is ready for adjudication now. Not some threat that something will happen in the far future, not some issue that has already been over and done with and somebody's just unhappy with the outcome, but something that is ready for adjudication now. And so we can ask, there is such a thing as a declaratory judgment. And so if Epic Games is feeling threatened by Dancing Pumpkin Man's alleged copyright infringement claims, they could go to court first. And that's what they did here. On October 30th, defendants sent Epic Games a cease and desist letter. The October 30th letter claimed that the Dancing Pumpkin Man is a character protected by defendants' intellectual property rights and that the Pump It Up emote was an unlicensed use of that alleged character's likeness. The October 30th letter demanded that Epic Games cease and desist use of defendants' characters' likeness immediately and indicated that defendants were prepared to take all necessary steps to protect the Dancing Pumpkin Man character. On November 6, 2019, Epic Games, through outside counsel, responded by a letter. The November 6th response letter explained various reasons why defendants' infringement claims are without merit. On November 12, 2019, Geiler responded by email indicating that any continuing unauthorized use of his character's likeness continues to compound the problems and the damage suffered by him and his company. On November 25, 2019, Geiler followed up with another email in which he explained that if he did not receive a substantive response to this settlement proposal by December 9th, he was prepared to engage legal counsel to insist in seeking injunctive relief pending a resolution of the dispute. Okay, well now that's a real legal threat. I mean, telling someone you're going to get an injunction against them, that's a really serious legal threat. Epic Games Counsel responded by letter reiterating that it disagreed with defendants' claims. Geiler's letters and threats to sue Epic Games have given rise to uncertainty and controversy with respect to Epic Games' ongoing right to use the Pump It Up emotes in Fortnite. Epic thus seeks to resolve this dispute as promptly as possible so it can focus on creating innovative video games that entertain players without the threat of litigation. Now, you might remember that Epic Games is not necessarily my favorite game store because of some of their shenaniganery this year. However, I'm showing you I'm nothing against Epic Games in that sense. I think they've got a really solid case here. I think this was the right move if they're being threatened with legal action. And I'm still really confused as to why somebody would threaten them if they got a license. And how did that work anyway? Like, we don't think we need to get a license, but here we'll get a license? I mean, that's smart. So if that's what happened, good for you, Epic Games. That was really smart. But, like, if that wasn't it, how did this happen? Like, how does somebody forget that they gave a license in the first place? But then, like, why were they getting a license for something they didn't need a license for in the first place? This Dancing Pumpkin Man thing was September 19th. I mean, maybe it was from a long ago and that was just a repost or something, but didn't seem to me like there was really any reason to get a license. Why would I get it? What would I need to get a license? Let's see. If I was representing Epic Games, I would say I would want to cover my butt by getting said license, and I would offer him several $100s and see if that gets me done. And if that gets me done, I would say, hey, we got something done for less than $1,000 to eliminate a risk on something people are going to pay probably many thousands of dollars for in total. So in other words, they're going to sell stuff in the game. And I'm assuming the Pump It Up emote is either for sale or you have to buy it. Somebody could buy it with money somehow, I'm sure. So I'm assuming they're making money off the Pump It Up emote. To resolve the claims raised by defendants and to afford relief from the uncertainty and controversy caused by defendants' actions, Epic Games is entitled to a declaratory judgment that Fortnite does not infringe any copyright or trademark rights defendants may own. Defendants' assertion that Epic Games has infringed their copyrights and trademarks adversely affects Epic Games. Unless resolved by the court, the uncertainty and controversy between the parties will continue to harm the plaintiff. So they ask for a declaratory judgment for non-infringement of copyright, which is exactly what they should do. Basically spelling out some of the same arguments they made before and explaining that there is a license. And same thing with trademark. Don't even see how it's possibly a trademark case. But apparently they made a trademark claim too. And so that's been filed by Kirkland and Ellis. Let's see what we can find on these exhibits. Maybe they have some fun things in the exhibits. So they have a pre-trial conference April 2nd. Okay. Let's go back to the complaint here. Summons. Oh, they've already got the summons. They've already entered their appearance. So here we have the Dancing Pumpkin Man video. Here's the license. Oh, and a CBC radio transcript. Let's take a look at these two. These things look interesting. If you've ever wondered why we pay $1,600 a year for Law 360, this is why. Being able to find this stuff quick is good. So here is Exhibit 2, the license. Wow, it's a choreography license. So again, why would they call it a choreography license if they think it's just basic dance moves? I mean, I personally think it's just basic dance moves, but they treated it as if it was actual choreography. And they got a license for the choreographic work performed by Matthew F. Geiler on behalf of licensor for his performance of the KXVO Pumpkin Dance posted on the KXVO 10 o'clock news YouTube channel on November 2nd, 2006. Okay, that explains that. He thinks it's a lot older than the 2019 repost that we saw. And then they give a link here to the actual YouTube video. Video unavailable. They took it down.
Great.
Okay, all that work to get to see the video. So they apparently do have some kind of license. And they paid $10,000 for the license. Okay, do they really think it's dance moves if they're willing to pay $10,000 for it? Holy mackerel. Jeez. So there appears to be a license. That's incredible. It's so credible that it discredits Matthew Geiler completely. I have no words to try and explain what in the world a person is doing when they sign when was this signed? It's DocuSign, so it has to be somewhat recently. DocuSign didn't exist for till recently. So this is August 23rd. Yeah, August 23rd, 2019 is the date on here. He is asserting some kind of copyright claim just 2 months later. Copyright and trademark just 2 months later. Why? He got $10,000 for the license, and then he wants to get more. I don't know. Was it greed or just some kind of like uncurable stupidity or something? I mean, that's one of the dumbest things I've ever seen, that someone would get a license and then sue over it. Like, that's like if I settled one of my cases and then they sued anyway. I would go to court and I'd be like, Judge, we have a license. Judge, we have a settlement. And the judge would be like, what are we doing here, Todd C. Banks?
So going down the rabbit hole, we've discovered a lot here.
Yeah, and we're not done. So here we have Exhibit 10. This is some kind of transcript. A transcript for Jeff Douglas and Carol Off on As It Happens. So now, technically, hang on, let me back out here, because this part is not part of my commentary. I don't want to commit copyright infringement here. I'm looking for something specific, right? I'm going to look for like Epic Games or Geiler. Let's try Geiler first. Here we go. Guest, Matt Geiler. To all the kids on Twitter, he is a sensational hero akin to Santa Claus. Every October, a video resurfaces to mark the beginning of the Halloween season. It manages to be, at once, chilling and ridiculous. I would describe it to you, but there's no one better suited to do so than the Dancing Pumpkin Man himself. We reached out to the legend that goes by Matt Geiler in Omaha. Okay, that explains some things now. So they paid him $10,000 because he is a very popular Dancing Pumpkin Man now, isn't he? If the CBC, the Canadian Broadcasting Company, is doing an interview with him on their As It Happens show. So let's just take a quick look. Obviously, this is a transcript of their show, so it's copyrighted. So I'm only going to try and do what I need to do to get my point across. So Matt says he is joyously gyrating in a black unitard with a pumpkin on his face in a manic celebration of Halloween. And so he did it 2 nights before Halloween in 2006, working as a news anchor. He had just gotten to the point in the evening where he was about to go live, but they had 7 minutes left before the show had to be stacked. So we were really scrambling to fill up the hole in the broadcast. So you gotta fill 7 minutes of air. And what are you going to do? So he runs out, grabs a black unitard and a pumpkin head, says to his producer, I want you to throw up a graveyard on the green screen, and he's just going to dance for like 4 minutes, and we can put that into the block right before weather, and it will eat up some time. You did this live. We didn't do it live. The broadcast was live. It was probably about 5 or 6 minutes before we went live, but you were the anchor of the news? Did anyone consider this appropriate? Well, there wasn't a lot of oversight. You had to cover this much air before in some way, and then he goes on. So I'm gonna back out here, and then it became a more or less a sensation, but not overnight. It grew out of BuzzFeed in 2009. It is now the greatest Halloween video the internet has ever produced, and has something like 6.5 million views and counting. It's probably closer to 10 by now, except either I typed in the URL wrong or it's down or something. And it's good to talk to you. Thanks. So that seems to explain things. Epic does think this might be some kind of choreography, or at least deserves some kind of license. They paid $10,000 for said license because they really did want to copy the fad of the Dancing Pumpkin Man. So they really were trying to make a dance move of Dancing Pumpkin Man. But it looks like they paid for it, like they're supposed to. So why did he then assert a copyright or trademark claim? He's very likely going to have to spend that $10,000 on his lawyer now. Why? Can someone explain this further to me? Because I've reached the end of my research and I can't figure this one out. Let us know your thoughts. Maybe you have some speculation. Maybe we should reach out to Matt Geiler and try to get an explanation of why he would think. Because this doesn't make any sense, right? Like, he's obviously not an insane person. We've covered some lawsuits by people we would consider to be not quite all there. This didn't sound like that. The not quite all there part is, why would he sue when he already gave them a license? Like, did you just forget you gave them a license? I don't think you did. I think something else is going on. So let me know. We'll figure it out. We'll follow it up. All right, well, that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I appreciate you putting up with my set and trying to be quiet as my partner is sleeping in the room next door, so I hope I wasn't too quiet, and I certainly hope I wasn't too loud to sleep the slumbering Loch Ness Monster, as Brandon has recently described her. So thank you very much to all of our supporters. This channel would not be possible without your direct financial contributions on patreon.com/ljfrench and sponsors.com/law. Thank you to our December $50 plus supporters: Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. Thank you very much to all of our supporters. The $50 and $5 plus supporters will be scrolling on the screen in front of me, and you will all appear in the description of the videos. Thank you very much for joining me. Thank you very much for watching. Thank you for your support. I love you all. I'm Leonard French, your favorite copyright attorney. Have a good one. Bye.
Kaylee, Anastasia, Petronella, Vendetta. Will you marry me?
Yes. Oh God. Yes.
No, I love you so much.
God.
I know I made you wait.
I know.
But I had to wait till the right moment.
Oh no, I wasn't expecting that.
Would you like to see what I did for you?
Yes.
Here you go.
Oh.
I made this box. The box is the ring
Okay.
I purchased. I made this box for you.
Okay.
So please,
Oh.
I will flip that so that you
Okay.
don't have to worry about that.
Oh my God,
But,
I'm scared. Oh my God. Oh my God.